Well, we have a number online. Some still might be coming, but we will go ahead and get started otherwise. If at any point, please, the chat, if the sound cuts out or the camera or feedback or anything, please do let us know. Otherwise, it should hopefully all be set up. So welcome everybody to our third seminar of the Michaelmas term. We are very, very excited to have Ryan Rowberry here from the Georgia State University College of Law. This is your third time in Cambridge, I believe you mentioned.
Yeah. Third time. No, I've never spoken before, but I mean, in terms of visiting, yeah.
Well, we're very excited to have you here to speak on the financial portfolio of Justice Gilbert Rothbury, 1295 to 1321. And Ryan is working on medieval judicial seals. It's kind of a macro project. This is related to the research coming out of that, sure. So without further ado, I will turn it over to someone you actually want to hear from, and you'll get moving.
Well, first, just let me say thank you for the invitation to come and speak. I pitched this in the United States, and they're like, who, what, how old? This was before our country. So I'm thrilled to be here, and I want to talk with you about I do a lot of work on medieval justices, the people, their connections, the networks. And tonight I want to talk with you about one specific justice named Gilbert Rothbury. He's not well known. He's not one of those that sort of pops up in the yearbooks he's there, but he's not a Barrowford. He's not any of these other fellows you might see. And it's really interesting because when I talked with my wife and my in-laws about what I was coming to speak about, they're like, well, who cares? Who cares about, do judicial finances matter? So I have here Justice Clarence Thomas from the Supreme Court of the United States, and right now judicial finances do matter in the United States. Here he is in his $200,000 RV, whose loan was forgiven by a very wealthy benefactor, and the questions are, is that improper? At the moment, the United States Supreme Court does not have a judicial code of ethics. Believe it or not, we had one in 1280 and 1290, but we don't have one today in the United States. So judicial finances do matter, and they matter for a number of reasons. I'm going to talk about the man, the judge itself, and then also how finances show us how he is connected to different people at different levels of society. So a bit of background first. Gilbert Rothbury. I have been to Rothbury only since studying about him. Rothbury is up in Northumberland. It's very, very far. It's still not a large place. The man was born in about the 1250s. We have documents from 1281 or so where he is acting in a legal capacity. We have no records about his education, but he starts to appear as a clerk of the Northern Air Circuit in the 1280s, and then when there is a sort of wholesale cleansing of the judiciary by Edward I in the 1290, when he returned from France, he became the first known clerk of Parliament, and also he became clerk of sort of the King's Council. In 1295, he was elevated to the King's Bench, a junior justice, and remained there till 1316, at which time Edward II pushed him over to the Common Bench, where he remained for 5 years. So we have sort of an outline framework of Justice Rothbury. Rothbury is kind of an interesting place. It's still, in the 13th century, there were 228 acres of arable demesne land, 21 acres of meadow. They did have a gallows there, which I guess can always come in handy. But it's still, even today, is not a large place. And so he's an interesting person because there is nobody else quite like him. There's no one else he's related to in the higher echelons of judicial power. He seems to be somebody who sort of received his education somehow and began working, and through serendipity and other means and skill, rose. We do have a few pieces of information about where he may have studied. These come from loan chests. So Rothbury, in his will, which we do not have, but we do know that it was in his will because some other records allude to a will, he endowed Oxford with 2 loan chests, the first with 200 marks, the second with 50. And I have up here the borrowing scales at which different people could borrow. The second chest at Oxford is quite interesting because it specifically states that the university could borrow money from that chest to defray costs of some sort. It never goes into what kind or what types of costs. We know the Oxford chests were in operation by a pledge note. In 1321, typically a student would pledge books or collateral. They would place it in the chest, and then of course that would be sold to recoup the loan if it was never repaid. But we do know it was in operation in 1321. He also gave money to Cambridge. We don't know how much. The documents are unclear. We do know the loan scale though. And so what makes it appear is, whereas a master at Cambridge could only borrow as much as a scholar at Oxford, which makes it appear that the endowment was somewhat lower, most likely, than what he gave to Cambridge. And so there seems to be some sort of, and it says in some of the documents, it says he has a special affection for those at Oxford. So it might be that he took a course or two there, had spent some time there, as many justices did. He never received a degree that we know of, but for this time period, that was relatively standard for many people. So he may have had some education there, we're not sure, but that's about as much as we know. This is one of the earliest loan chest endowments at Oxford, and it still existed all the way up until about the 1750s. It was still in operation, which is quite interesting. The Cambridge chest, it became part of, from what I can tell, part of Clare Hall, from what I understand, and it was eventually just sort of lost to time. We're not exactly sure what happened to it. So when I was looking at the income for Rothbury, I sort of divided it into three phases. The income he gets from the Crown, that he gets from private patrons, and the income from different litigants. And I'll just kind of work through these. And as we move through these, it is about the money, but it's also about the people. And it's really interesting to see, from my perspective, how the finances shed windows of opportunity and sort of onto these different networks. So the Crown, well, he did receive a salary, typically 40 marks a year as a junior justice. He was there for about 25 years, so that should amount to about 1,040 marks. Now, Professor Sales used the Liberate rolls and sort of charted in the Selden Society volumes the different amounts that the different justices were given. And I have those here on the left-hand side. Those are the Chancery writs. And you have the date, the place, and the amount. Now, that is obviously not how much they received at the time. That's how much they were allowed to receive. What I did, which Professor Sales did not do at the time, in which I connected those to the Exchequer issue rolls to see when and how often Rothbury pulled money from the Exchequer using these writs. And what you see is it can get quite interesting. I still haven't found the one that corresponds to Dunfermline, but what's interesting is that he's using, especially when you come down the chart here, he's using the same writ multiple times to pull out actually more money than he's allowed. So the writ is for 240 marks, but he cashes it 3 separate times for 240 marks each time. And there are discrepancies with how these operations are happening at the Exchequer. Now, I've just sort of stumbled onto some of these things, so it deserves deeper exploration. But I did check with Roger Brabazon, which was one of his colleagues on the King's Bench, the Chief Justice. He did the same thing, where they are using so this writ at some point should have been invalid. You take your 240 marks out, either the tally or the writ should go away, but somehow they were still able to draw from the Exchequer. So it's an interesting piece that deserves further explanation, which I don't currently have at the time, but it's one of those interesting pieces that you find, I think, through looking through some financial records. He also received some robes, and of course, Professor Sir John Baker has written a lot about judicial robes. Here's our 15th century Court of the King's Bench from the Inner Temple Library. You can see the judges are wearing their scarlet or crimson robes in the back. They would have been the most expensive. They would have had 2 other sets of robes, violet for the winter, lined with miniver, green for the summer, lined with some sort of lightweight silk. I have an estimated annual value down there because there is no direct evidence for how much was there a money commutation? We're not exactly sure. So I estimated a banneret of the king's household. We know that they were sort of given this amount of money per year for their robes. So I'm assuming that, the king's chief justices and the king's bench and common bench may have been somewhat similar. That may not be true. At this point, I don't know how much they have or don't have. Now, justices also received gifts, and these can be difficult to quantify, particularly the deer that they were given from the royal forests. Venison, of course, was a high status meat at the time. Gene Burrell, who has written a lot about the forest law and forest animals, said there was no open market for the meat. You could buy it in London, but it was only available to the wealthy, and without there being an open market, it did become the subject of smuggling in the 13th century. I guess you had an underground venison trade of some sort. So it's very hard to quantify in terms of value, sort of what he was given in terms of gifts, but they were there and they were somewhat plentiful in different times. So the crown is sort of one revenue stream that the courts, that court justices and Rothbury in particular could take advantage of. Private patrons were another. And there's sort of three different ways that justices could look to private patrons for some wealth. First is retainers, which happen quite a lot. Second, with clerical justices, and Rothbury is a clerical justice, he's both a priest and a justice. Benefices became a very big piece. We'll talk about those. And then the all-important question of bribes. Were there bribes? If so, how much were they? How do we know? But we'll start with retainers. Rothbury had one retainer that I know of. He had several other that I can imply that there was a retainer, but I have no hard evidence. But he did have a retainer from the Knights Templar. In the November 1296, he was given a pension of 100 shillings per year until they provided him with a benefice. However, following their sort of demise in the early 14th century, Rothbury still had not received either the pension or the benefice. And when Edward II opened up the opportunity for people to claim against the lands and goods of the Knights Templar, Rothbury filed a claim. And his claim was, I didn't receive either the pension or the goods. And he brings a document to court showing that he should be allowed 100 shillings per year. He won his case in record time. And I wonder, we have no idea who the justices were. Were they his fellow justices sitting on? I don't know who they were, but he won it and he was given the money plus arrears. And he continued to receive this money for the remainder of his life because they did not provide him with a benefice. Bribes. We're going to handle bribes first. Now, as I mentioned before, in 1290, Edward I had sort of swept aside a lot of the royal justices on the common bench and king's bench for alleged bribery in many cases. That is immediately in the background of the allegation against Rothbury. Rothbury, the abbot of Mellifont, which is in Northern Ireland, he claimed that in 1297 that there was a lawyer, rather the lawyer claimed, Walter Bodenham claimed that he said Rothbury would do nothing without a bribe. Those were the words he uses in his allegation. He alleges Rothbury wanted £25 in order to settle a £300 obligation for the abbot of Mellifont. Walter Bodenham was imprisoned at Newgate. Rothbury said, "You've slandered me. I did not take this money. I know nothing about this." And eventually, 2 years later, all charges were dropped. He was never fined. He was never questioned. And so the only conclusion I can come to is that it was sort of a piece of, verbiage from Walter Bodenham. What's interesting about him is he would also go on to continue his legal career, despite being imprisoned in Newgate and sort of slandering the justices. He continued to work for the abbot up for the next 20 years. So we have no evidence that he took bribes. Some of the things that you and I might think of as bribes today would not have been considered bribery at the time. They were allowed food and drink for the day, of course. That was customary, and occasional gifts. But in terms of an outright bribe to change sort of the outcome of a case, no firm or solid evidence in terms of Rothbury. For other justices, we do have firm and solid evidence for both. The big piece of Rothbury's financial portfolio, and all clerical justices that I've dealt with before and since, happens to be the benefices at the time. And we're going to go through this in just a little bit. I did take the moment today when I was in downtown to sort of go and pay my respects to Harvey de Stanton, who's buried there in the church, who was a colleague of Rothbury's. And in the handouts, I gave you his benefice chart, so you can see what benefices he had and how it operated. But as you can see on the left-hand side, I have the position that Rothbury held at the time, the years, and then the different benefices and the patron. And benefices is just a living. It is the land and goods attached to a particular church that's supposed to support the priest. You might be wondering a little bit of like, wait a minute, I thought there was supposed to be one priest, one parish. And that's the ideal. Most justices who were clerics were pluralists. So they held several at the same time, and they collected several benefices, and they would then farm out the parochial duties to others for a small fee. So Rothbury, you can see when he becomes, in 1295, which is right over there, once he becomes a junior justice of the King's Bench, he starts getting more benefices, as you might imagine. People want connection to him, particularly this benefice right in the middle from the Bishop of Durham of Staindrop, an annual value of over £93, which that's an immense amount of money, particularly at that time. But he both a prebend and at Staindrop and a prebend also in Durham. The Prior of Ware was his patron for 3 different benefices. Then he has the Abbot of Chester, the Prior of Eye, the Abbot of Ramsey, and Westminster Abbey at different times. And so benefices, as you go across here and you sort of tally up the different amounts, or at least annual amounts, this far exceeds his royal salary, tenfold, 20-fold. And that is not necessarily a bad thing. Sometimes the king, I know, wanted his justices to have connection to the good and the great throughout the realm, to have sort of the patronage and the eyes and ears on the ground and sort of lubricating the wheels of justice. Perfectly fine. What is interesting with Rothbury and with Stanton and with all the others who were clerical justices at this time was that in 1317, late 1317 in November, the Pope issued a decree called Execrabilis, where he outlawed pluralism. So he said you can have one benefice and one prebend, and that's it. And as you can see, it actually worked to some extent. Rothbury, we have records of him resigning his benefices in different places at this particular period of time. So his annual benefice value goes from £221 to £61 in the matter of a year. Still a lot of money, but it's a huge diminution in value. And we find the same thing with Stanton and with John Bacon, who was the other clerical justice at this time, that execrabilis was actually enforced by the bishops here in England to some extent. You'll notice the rule was you can only have one, but Rothbury still has 2. He still has the £40 a year, which is his most valuable benefice, and we'll come back to the Abbot of Ramsey. But he also still has Westminster Abbey, and I can often see Westminster Abbey wanting to hold on to a connection since the justices were sitting there and they were always around there. They still have that connection to Rothbury. And what's interesting here with his benefice of Staindrop is there's a document in the Register of Bishop Kella that says Rothbury has died. It's 1316. He's died, and we're going to institute someone else in his place. And he clearly hadn't died. He lived till 1321. I mean, he was still, there's feats of fines. There's plenty of documentation to show he was alive and well. He went on general air, etc. And so I've been trying to figure out why there would be this notation in the bishop's register, because there does say there is a person, another person has been instituted into the benefice. What did happen with sort of the rise of the Scots, and there was a lot of ravaging at the time, they had to revalue this land, and it dropped from 93 pounds to just under 60 pounds. So lost about a third of its value according to the valuations. And I have to think at this point, Rothbury's getting a little older. He's probably not traveling up to the north anymore. It's a new bishop. Most likely they want somebody who's there, whose patronage they can rely on, and that's not going to be Rothbury. So they actually, either they thought he was sick, or there was a rumor that he died, or in some way, this gets into the register. And it's surprising to me, the piece that's surprising to me is not that there's a registered death in the register, because that happens with several other people. There's a mistake, it happens, things go back to normal, is that Rothbury never contested it. There is no evidence that he ever contested this, and this is an incredible amount of money, whereas he contested the 5 pounds a year from the Templars. So I'm still not sure what to make of that, but it is sort of an interesting piece. And when you add everything up together, over the course of his life, he probably received somewhere around 4,500 pounds from benefices alone. And more importantly, is the patrons he was connected to. And we'll come back to that, especially the Abbot of Ramsey, who wrote a letter that survives that talks about Rothbury. Litigants. Litigants also play a large role. Now, judicial writs. This is something I've been working on recently. On the right-hand side here, you have what's called a writ file, which is a bunch of those judicial writs. We only have one, we think, complete set of judicial writs with their original covers from the 1296. The rest, they're pieces scattered all over. But this is what they look like, and they're, small strips of paper. They're sending out writs, attachment, distraint, summons, those kinds of things. So some of these would appear, many of them would appear on the plea rolls. So if you're, for an original writ to initiate litigation, you pay 6 pence, 6d. For judicial writs, issued in the course of legal proceedings, you pay 7d. And from that, 1 penny per writ goes to the justice, or to the justices. Now, we're still not sure, and this is what I'm currently working on, how the division was, there's typically 3, 4, or 5 justices at any one time on the common bench or king's bench. Did they share the profits and divide them equally? Was there some sort of, well, those with your name on the bottom, you collect a penny for that writ? So the big question is, and Hastings in her book and Bertha Putnam in her book on Shershel said, we don't know how many writs there are, but this is probably a huge amount of money for the justices. And that may well be. It's hard to quantify this. I've tried from the best we have with the earliest clerk of Hanover records that record the profits from judicial seals are not till the mid-14th century, so much later than our period. And we know that the traffic increased in the courts at that point. At this point in 1368, for that year, you had 1,416 judicial writs in the King's Bench, and almost 10 times that in the Common Bench, which is to be expected. So, but when you take a penny of each of those, and you sort of divide those into pennies, it actually comes down to only 50 pounds or 6 pounds, and that would have been maybe divided between the justices. In Michaelmas term 1400, we find a ratio of 22 judicial writs for every 1 original writ that made it onto the plea rolls. Whether those same ratios and proportions hold true for the early 14th century is something I'm working on. At this point, we do not know. But preliminarily, it looks like writs would have been a very minor source of income for Rothbury. He would have had something from the writs. And the sealing and who is doing the sealing, how the sealing is working on these judicial writs, that is something that is part of this larger project that I'm working on. But the income itself seems to have been negligible, particularly in light of his benefice income. But more to come on this. This is still sort of some virgin territory that I'm trying to explore. And there will never be any pure satisfactory answers because we don't have all the writs. They haven't all come back. And when you work with them, you walk out with blackened hands. And I mean, people are like, what are you doing up there? But they are really interesting documents that have been little studied. Finally, the last piece to look at here is judicial commissions. What did they do during vacations or commissions at different times? So I went through the different roles from the surviving documentation, from Ore Termine commissions. He participated in over 35 of them in the course of his judicial career. We know that at this point in time, often the person who paid for the commission often had discretion to choose the justices, which makes me think of some other links. He's often found hearing poaching cases from the Earl of Hereford and from the Earl of Lincoln. Those two, and from Edmund of Earl of Cornwall. Those three account for 27 out of his 35 commissions. And so at some point there must be a relationship there, or at least they liked how he did his job. I have up here, there was a woman who paid 2 marks in 1314 for a judicial commission. Often there, of course, was a fine attached to getting one of these commissions from the king. How much did they earn? How much did they didn't do this for free? We know that. Well, the only reference I've seen, and it's very oblique, is in 1299. Rothbury was part of a team that heard about trespasses in chase and parks from Edmund, Earl of Cornwall. Edward I grants all of the proceeds back to his brother, aside from the portion to be taxed by the said justices. Now, at what range, we don't know at this time. We do know in the later 14th century, the range tended to be about a third. A third of whatever damages were collected from the commission would go to the justices. Whether that's true here or not, I don't know. But I think rather than judicial writs being sort of one of the large sort of pots of money that went to the justices, it really probably is more of commissions. Again, more work to come. Also, bishops like to have Rothbury act as an assize justices for novel disseisin between their tenants. 7 different times that I've found over the course of his career, they gave him a license to do this, and he would have been paid for that as well. All right, what does this all add up to? So underneath, I've put the amount, when we know it, of different amounts of money that Rothbury received from different sort of income streams. You can see we know the least about this because the commissions, a lot of those roles have been lost. I'm still working through some of the other ones. Private patrons and the benefices really takes the cake, far more than the crown. And this leads to some tentative conclusions. So during his judicial career, from the sources I've found thus far, he averaged more than 225 pounds a year. We always knew judges were rich men. Maybe we're finding out just how rich. His last 10 years were even more lucrative, probably more than 300 pounds a year. Again, 100 times more than some of your, most of society. And I think this is the really important one, is 83% of his income came from sources beside the crown. So most 80% from benefices, a little bit from retainers, judicial writs, and then commissions have to be in there somewhere, yet to be determined. But like any sort of tentative conclusions, it actually brings a lot more open questions to the fore. And these are ones that I'm currently working on. What latitude did royal justices have at the Exchequer to collect their annual salaries? Because apparently either somebody wasn't assiduous or they had some sort of special dispensation. The king owed them back money. They could use a writ to collect that back money. The king is often in arrears to the justices. That is clear. So perhaps that is the answer. And also, what was the sealing practice for these writs? What did they look like? How large was the seal? We know that for original writs, they would just use the corner of the seal. They wouldn't put a whole original unless you wanted a patent or you had to pay for it. They would just sort of dab it into the wax. Was the same done with judicial seals? What makes this more interesting is that up until 1344, justices used their personal seals for professional business. It wasn't until 1344 that justices got a judicial seal that they could use. And so, but nobody has gone through and sort of cataloged, what did these seals look like? Do they even exist anymore? And I've found examples of about 8 to 10. so far. And I'm currently working up a paper on judicial seals because they would have also been used as their private seals at the same time. The justices split the profits evenly. Again, open question. Could financial ties, and I guess this is the overall question, is could financial ties have influenced his decisions at some point? Again, he was never charged for bribery, so we don't know. But we do have an interesting letter from the Abbot of Ramsey, who is his patron. 40 pounds a year is what he gets for his benefice. And he writes to Rothbury in 1312. And he invites him, number one, to stay at Ramsey Abbey for Christmas. He's like, hey, let's share Christmas time together. And number two, he said he thanks him for procuring specialized chancery writs and promising to pay him cum usura, and also requests particularly sensitive information regarding parliamentary proceedings. Again, we don't know what exactly went on, but it's clear that Rothbury could be probably influenced and could influence his patrons, and that was, somewhat typical for the time. It was not atypical. The question is how much, and we don't know that for sure, but we do know that they operated within a web of patronage, where this would probably to have been expected a little bit. At the end of the day, these were rich guys. So Harvey de Stanton, buried right over there. He had 800 pounds at Bury St. Edmunds that was requisitioned by Isabella and Mortimer when they came into England. He also founded, of course, a Cambridge college that was eventually absorbed into Trinity College. John Bacon held manors in multiple areas. Rothbury founded the loan chests. These are all clerical justices, so they had parochial as well as sort of secular power. And it's really these kind of relationships that I think, looking into financial records, they can really share with us these different network ties that actually then move to the operation of justice. Just as the same goes to say with Justice Clarence Thomas of the United States Supreme Court. The question is this particular gentleman who has helped him out and paid for many things in his life does have own companies that have business in front of the U.S. Supreme Court, and does that compromise judicial integrity? Most of all, I appreciate you being here on such a dark evening. Thank you so much. I look forward to your questions.
Well, thank you so much, Professor Rowberry. That was absolutely fantastic and a fascinating discussion. I know you guys can't see me right now. I will go ahead and abuse my commoner's privilege to ask the first question, but if anyone online would like to type their question up, it'd be a bit easier on us. Otherwise, just put your hand up, and then of course in the room as well. So I think the real takeaway from this for me, that was just, as you pointed out, so fascinating, is just the discrepancy in the benefits as a source of income compared with all of these other potential sources of income.
Yep.
And I'm curious, could this suggest that this is an attempt by the ecclesiastical authorities, in a sense, to maintain some degree of influence or control over the common law courts as they kind of grow out and above the ecclesiastical courts?
Sure. I mean, you can look at it that way. The Pope is complicit in this as well. That's the flip side. Is often you have their papal licenses for them to hold multiple benefices at the same time. Mm-hmm. So I don't think, and every clerical judicial person was doing this. So it's not out of the norm. How much this is an attempt by the church to control the common law courts is hard to say. So it was not an overt attempt in any way. This was sort of best practices. It also means that the king doesn't have to give them money, right? He's like, if he can have the clerical patrons, foot the bill for keeping these guys in good house and home, then it stops the king from having to give them manors or other things. So no, I don't think it was an overt. I just think it was part of the practice at the time.
Sure. Do you have any questions in the room?
So just to follow that, from total ignorance, you can presumably look at other benefices granted by the Bishop of Durham.
Mm-hmm.
So who else is getting them from the Bishop of Durham, and are they at similar levels?
That's a good question. Similar levels to this, no. To Steindrop. I do know of two cases where the benefices are going to people that work very closely and stay in the Palatinate in Durham. But the size of the benefices were smaller than this. They were 60 pounds per year, which is still a lot, but they weren't 93. That's an excellent question and one I'll look into. So, but I will look into that.
Yeah, they're in the room.
Again, from Total Ignorance, I can't help thinking about the judicial have-nots here. Is there any sign of jealousy? If you've got judges sitting on a bench and one of them's getting a huge amount from something unrelated to judicial activity, which might be influencing their activities, any sense of other judges resenting this?
Well, no sense that I have come about at the beginning. Now, what you do have is we're standing right at the cusp of this change between some clerical justices to a completely lay judiciary. In the next 20 years, so by 1340, that change is complete. And at that point, the benefices don't factor in at all. Then you get the age of retaining. And what you see is the retainers per justice skyrocketing. So benefices are out of the picture, but now they're being retained by 6 or 7 other houses, not to the same levels of the benefices. But yeah, I think there were probably some jealousy involved. I would imagine so. I guess it would be maybe not human to think otherwise. But we don't have any sort of specific documentation. The sergeants were doing quite well too, right? And that's the pool they were drawing from eventually. So at this point, I don't sense any jealousy, but we do see the shift from benefice retaining, as I call it, to monetary retaining in the 1340s and 50s. And then that, of course, becomes a problem, and they try to clamp down on that as well.
I'll ask a somewhat related question. Looking back a little bit to the 13th century, earlier in the century, there was a lot of popular perception, of course, that the judges in the courts were,
You bet.
corrupt is maybe too strong a word, but certainly that there are issues going on. Is there evidence then, and from a popular standpoint, not necessarily a clerical one, that this was egregious, that this?
Well, I mean, the biggest time where we can see it's sort of stepped over the mark was in 1290. Because when Edward came back from France and there was outcry that with bribery, people were changing names in the rolls and things like this. And Edward then starts sort of an investigation. And that then, sort of cleans house for a year or two. And of course, 10, 15 years later, the same people are reinstated back as judges again. In terms of popular opinion, I think it's always been fair to say that they have thought the judges were, making way too much money and not doing enough, or were corrupt. I mean, there's even a wonderful early 13th century ballad called the Venality of Justices, a popular song, I mean, so I guess, maybe the pop stars of the day were singing something like this. But with the Trail Baston exercises in the 1305, yeah, there's a lot of popular perception that law is essentially corrupting, and that, you need to have a good lawyer to defend you, but you can't even trust your own lawyer necessarily. That is very real in the 1290s, and again all the way through Chaucer and up through the 14th century. That never really, I don't think that ever really changes that perception, at least from the popular ballads and things that we have. Yeah, there's a perception that these people are somehow making their money maybe in not as an honest a way as they could. So, yeah, interesting question.
Do we have any questions online? I've been neglecting our chat. Doesn't look like it. Any more in the room? I can ask all day. Yeah.
The Liberate rules.
Yes.
Are those absolutely complete? I'm looking at what appears to be the same writ being used. That seems implausible, but it may well be right. So, it may just be that what you see on the Liberate rolls is not complete.
The Liberate rolls are as complete as, they're probably not complete. None of the rolls are entirely complete. And that may be some of the reason. What happens in the issue rolls, on the Liberate rolls, they give identifying information, date, place, amount. And then that is copied when they come in with a tally to take the money out. It's actually the same place. It will say, this is from a writ of Liberate, date, place. So you can track when they are pulling money out in the issue rolls. So it is sort of identifying information. So I don't think from what it says, they usually, the documents say they came in and either with 1 or 2 tallies removed the information, but they do list where they're getting the money and where the writ of liberate originated in the issue rolls, which I found that's the only way I could line them up, is they actually state, oh, this was given on this particular date, and this is the date when they've actually cashed the tallies. So are they complete? I doubt it. I doubt it. But they're complete enough to give us some sense, I think, that you can. I want to do a larger paper on, and that's what I'm going to be spending the next couple of days on down in Kew, of sort of lining up these issue rolls to the writs to see across justices, to see how did this actually function? And can we get enough of a good sense of this to see how did this process work? And again, how much money was taken? Was more taken out than was given? You know, was it sloppy accounting? Or was it, or how did the exchequer operate with justices? Because they would have all known each other. I mean, they were all going on commissions together. They would see each other all the time. They're not far away, just in the other room. So they were very familiar with one another. So this deserves a bit more explanation.
I wonder why it's starting the 1308 one for so long.
Yeah, I don't know. What's interesting is that Rothbury was only paid $860. Now, after 1317, if he would have received all his salary, he should have been paid $1,040. After 1317, he's owed money by Edward II, but Edward II never pays him. But Edward II pays all of the other justices on the common bench. And that's something, somehow did they have a falling out? I don't know. But all the other justices are receiving, you know, sometimes a year or two late. They'll lump the sums together because they're using the sums elsewhere. But Rothbury never gets paid after 1317, whereas he should have. And all of his compatriots on the bench are. And I don't know why. It's one of those mysteries. So, yeah. Yeah, this I think is proving very, very fruitful, and I think could be really, really interesting. Hopefully, and I'm hoping they're as complete as possible.
Well, I was just thinking, after 1317, Rothbury, is he the only justice who's getting benefices?
No.
Right.
You have Harvey de Stanton and John Baker.
Yeah.
You have those two who are
And
still
they're getting paid by the king as well.
Yes. Yep. So you have those two. So yeah, I mean, and I didn't plan on finding most of this. Just as one does, you go in with a certain sort of vision of what you're studying, and then these interesting sort of sidelights sometimes actually become the focus. But I think what they do for me is they start to shed light on some networks that were previously unknown, and sort of power dimensions and structures, as well as just internal practices and how did the exchequer function? How did they, when a justice goes out on commission, what do they do? When a justice seals a writ, are they sealing it? Is a clerk sealing it? Is it sealed with the full seal? Is it sealed with the dab? You know, all of those questions are has been brought up through sort of looking at this kind of one obscure justice. Let me end with one interesting little quote, because we don't know a lot about this guy, but there is an interesting quote from Chief Justice William Barrowford in the my mind is blanking, in the yearbooks, excuse me. So Barrowford, he was sitting with Rothbury judging a case, and we don't know much about Rothbury's background. I presume he was very poor, and this is what Barrowford had to say. So in a sharp rebuttal to one of the sergeants, that if a writ of ale, I'm not even sure if I'm saying that right, ale, a claim for rights through land of a grandparent. Is that ale? Okay, ale. If they would have found for the opposite party, then the opposite party would have recovered, which is sort of like, no duh. Barrowford stated the obvious. So would have the greatest stranger in the world have recovered the inheritance, or Gilbert de Rothbury, whose ancestor had nothing. That's 1320. And he probably pointed to him because he was sitting right next to him. He was making his point. And so I think Rothbury is one of these intriguing figures which rises from obscurity, and through the church, through some education, through some serendipity, and through the law, and through his intelligence and hard work and longevity, was able to command quite a lot of money during the course of his lifetime. But he did not acquire lands. He didn't, unlike most justices, he did not acquire lands. He did not found a college. He founded the loan chests, and that was about all we know. So.
Well, before I let you go, one more. I have to take the opportunity.
My pleasure.
You had mentioned the examples of the cases that the justice participated in himself that he was successful in.
Yeah.
Is there any evidence from a wider perspective of all the litigation he was individually involved in that he universally succeeded in his suit, or was it kind of more along the lines
We don't find him in many suits. And part of the reason for that is he did not acquire land. You often find Hingham and Barrowford and some of these others that there's feats of fines and other kinds of roles that deal with their acquisitions. And so sometimes they'll come before the court or their buddies. And I do find them recusing themselves. They step down when it involves their particular parcel of land. And what's interesting is they didn't go very far, because the next one, they're on the foot of fine. So they sort of like step down, and something was heard, and they step back into the bench. But Rothbury it's relatively silent, because he did not acquire lands, and that was not sort of his purpose. For whatever reason, he's unique in that respect. All the other clerical justices acquired lands as well, left endowments, etc., but not him. So for some reason, he decided not to.
One wonders where the money went.
Yeah, it's really, we do know that he farmed out his benefices to people. We do have cases where he is successful, where the person he farmed it to, didn't pay him on time. We do have that. And where he says, you owe me 40 pounds for this particular benefice, and it is 40 pounds. So it sort of confirms the amount, and these are all from the Taxatio Ecclesiastica of 1291, 1292. And he does win those. There's two cases where he says, you guys you're supposed to manage this for me for the amount of 40 pounds. I haven't received it. Please pay up. But then we don't hear the end of it. It disappears from the plea rolls. Sure. So presumably they paid. So.
Final chance for questions online or in person. Well, with that, all that remains is to thank Ryan again for absolutely fantastic seminar, and for coming all the way from.
Well, I just appreciate you all coming out here. I know it's like midnight outside. It's so dark out there. But it was a real pleasure, and I appreciate you inviting someone who went to Oxford to come to Cambridge.
We make allowances.
I appreciate that.
Well, we will head off to the Granta for the customary pints, and then we will be back in 2 weeks, I think it is, for the annual lecture, and we look forward to seeing everybody then. So,
Great.
Thank you.
Thanks a lot.